Hi, everyone. My name is Edmund. I'm here with my partners, Jennifer and Cindy. We're the lawyers at Amity Law Group in Rosemead, California. Today's topic is about a question that we get quite often. The question is, do I need a living trust if I don't own real estate? So it makes sense. It's obvious why homeowners need a living trust. The biggest reason is to avoid probate. The average cost of probate for homeowners in California is roughly $34,000. And so financially speaking, in terms of math, it makes sense to set up a living trust for your family. Now, the question that a lot of people don't understand is, what are some scenarios that would require, or even scenarios that we recommend a living trust be used to help your family, even if you don't have real estate? So we put together 4 scenarios for you today. And Jennifer, Cindy, can you share the first scenario with us?
Sure. So in California, if you die with more than $166,250 in assets, you're going to probate. Those assets are going to go into probate. Anything beyond that is going to go into probate, which is a very long process. It's an expensive process. So we want to avoid that. So if you know that you're going to pass with more than 166,000 or even somewhere close to that, better to be safe and create a trust in order to pass on those assets without having your heirs go through probate. If you want to, the other scenario is that if you want to control how your children receive and use their inheritance, you can do that with a living trust. So all those assets that you're leaving, you don't want it to just go outright, because that's what's going to happen if you don't have a trust. You want to set up a trust to decide and how your heirs are going to receive those assets. They could receive it in payments or structured payments. They can receive it when something significant happens in their life. So it's really up to you and how you want to structure it, but it could happen. You can permit them to use money only for college or anything that you think is productive. So you can decide how they receive the money and how they use the money.
Yeah, and another scenario would be if you have minor children. So a minor is considered anybody who is under the age of 18. And so what we typically advise is within your trust, you can name a guardian. So in case something were to happen to you and you pass away and your children are still under the age of 18, then you have somebody that you trust to a point for them to basically take care of your children until they reach, the age of majority. And if you don't have that set up and have a guardian named in your living trust, what they'll need to do is have to go through the guardianship process with the court. And that is a very, very complicated process, lengthy, expensive, and time consuming. So if you do have minor children, we always advise you, at least have a living trust set up where you name a guardian so that they can make sure, somebody you trust, somebody you know, somebody you, are basically have a peace of mind that your children will be taken care of if something were to happen to you before they reach the age of majority. And another thing is, like Cindy said, you can structure how they receive certain inheritance. So if they're 18, then they're legally able to basically inherit money. So if an 18-year-old, they are not going to be as responsible as you would hope with that money. So if you have something structured within the trust that says, hey, at the age of 18, yes, they're legally able to receive the money, but maybe we're not going to give them everything just yet. Because they're going to be in college, we'll pay for tuition. If, they graduate, they're going to, hopefully either go to graduate school or find a job. So we don't want to inundate them with just a lump sum inheritance, we want them to be staggered, then you have that set up and you don't have to worry about it. So that's the third scenario, basically, is if you do have a minor child, then we do suggest you have a living trust set up. Another scenario is if that child that you have has special needs. So a special needs kind of individual, typically the government will be able to issue some assistance to that child. So we don't want them to inherit a lump sum of money and be disqualified from receiving government assistance. So if you have a special needs child, then we would set up a special section within your trust that would specify kind of what conditions this child would be receiving this inheritance. And typically we want it where, you know, it won't disrupt them from receiving government assistance or somehow disqualify them from receiving government assistance. And again, you would name somebody, you know, that you trust, a trustee, to help manage that and make sure that your special needs child receives, you know, the maximum government assistance as possible, and then still have some money set aside for him or her in case they need it for other kind of expenses or day-to-day kind of, you know, living expenses. So we call that health maintenance and support. So you have that kind of set aside, making sure that, you know, the special needs child is protected, basically, and have something set up for them where it's an individual or somebody that you trust would help them manage the inheritance in a separate account so that it doesn't interrupt or disrupt or disqualify them from receiving government assistance.
So as you can see, there's so many different types of scenarios where a living trust makes sense, even if you're not a homeowner. And if you have any questions to see whether or not a living trust is right for you and your family, we offer free consultations. Right now, we're only offering phone consultations during the pandemic. And so give us a call and we would love to help you determine whether or not a living trust can help your family in your particular situation. Okay, that's it for this video. Thank you so much for tuning in, and we'll see you in the next one.